a whole mess. I can sit here all day long and my signal does not go out. But the moment that I try to do something productive, there goes my signal. So I'm going to wait until there are people that come back in, and then we will get started. So come on in or come on over. I can't believe they cut me off. I'm not playing any music now. Maybe that's what it was. Maybe they found out that I had some music. All right, so just come on back. I'm sorry. Just come on back. I didn't give that disclaimer that I do not own the rights and all this of music, all that type. I don't have time for all that shit right now. So what I was saying is that there were two trends that I saw. That I'm glad you're back. I'm back too, because don't get me started on social media right now. No, it wasn't just you. I'm back on. Okay? All right. So anyway, the reason why I left the public defender's office was for two reasons. The first reason was that my younger clients, so I'm talking clients that were charged with adult offenses, they were getting younger and younger. All right, that was the first trend that I saw. The second trend that I saw was that when I had statement or confession cases where my clients have been accused about making statements about what has been going on in their cases as it relates to whether or not they are guilty or not guilty of an offense. When I would go and have meetings with them, I would sit down and review the statements with them, and there were many of them that could not, one, explain to me what rights or responsibilities they were waiving, that they were accused of waiving, and then two, there was a number of people who could not literally read me back the confession or the statement that they were accused of making. They couldn't read it to me. Even though their signature was affixed to the bottom of their sworn confession. And so what I thought was, if I can debunk the criminal legal system, then that's what I was going to do. I wanted to make sure that access to legal information did not come on the backs of those who were charged with crimes, whether they did or they did not commit it. That wasn't the issue. The issue is, in law, as in medicine or as in mathematics or as in finance, there is a certain language. There's a lingua franca, which is a language of currency. And the language of currency only works if you are able to use that language. Think of it like code switching. So if you are in court and if you are brought into a courtroom and your attorney says blah, 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 and the prosecution says blah, 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 and then the judge says blah, 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 and then next thing you know, you're taken back into custody. No one has explained to you what is going on, what are you charged with, and what you are facing. And so can you imagine somebody taking their hands and putting it over your mouth, and you say nothing except yes, sir, no, sir, yes, ma'am, no, ma'am, I plead not guilty, or something like that. I don't like when there is so much power that is only assigned to a group of people. I remember when I was in court, I went to support a loved one, and I heard someone who was sitting down the row saying, what's going on? I don't understand what the F is going on. The attorney hasn't talked to us and blah, 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 and things of that nature. And I told my family who I was with I would be right back. And I slid on down to the row and I told them what had happened with their friend or what had happened with their family member. And they were saddened, but they were also empowered. They were saddened because by the time they understood what was going on, it was too late. But they were empowered because someone had taken the time to explain to them and not talk to them in a way where they felt less than. When they were sitting in a courtroom where the odds are already stacked against them and against their loved ones. So they felt empowered because I was able to speak in that lingua franca that would allow them the chance and the opportunity to feel like they are invested and they feel seen as it relates to this particular case. And so I do that a lot of times, not to say, and I actually told them, they said, well, how do you know all of this stuff? I said, child, I'm a lawyer, but don't tell nobody. And then I just slid back over, and it was kind of like a little laugh because it kind of broke the stress of watching someone. You've been waiting there for 12 hours to see your loved one come out in 5 seconds and then go back in the back. And so that's why I am here. All right. That is why I'm here, is to show and to share information, because we know the adage that information is power and knowledge is power. But it's not as powerful unless it is accessible, unless it is relevant, and unless it's correct. Because I see a lot of Facebook pulpits and podiums being erected with the sharing of information, but there's no knowledge being transferred. And so this is why I'm here. All right. So with that, because, I'm a church girl. If you didn't know, I still have, protocol. I am now going to go into why we are here. There are 3 objectives with tonight. There are 3 objectives. And excuse me, I'm looking back and forth between my phone and the computer, because the next time we do this, I am going to upgrade. All right. But right now, we use what we got the best way we got it. So there are going to be 3 objectives. The first objective is to understand what charges were brought and what charges were not brought against Derek Chauvin. All right. What charges were brought, criminal charges, and what charges were not brought against Derek Chauvin. I think that's how you say his name. We'll just call him the defendant. Don't get me started. All right. The second objective is to examine why these charges are important. Okay, why these charges are important. And 3, to explore where do we go from here. So those are the 3 objectives. I promise you there's going to be a time where I will, upgrade, and I will be able to share my notes with you, and then you are able to share the ones that I publicize, so that you have this information which you may or may not remember after today. All right. So 3 objectives: to understand what charges were brought and what charges were not brought, and to examine why it is important, and to explore where do we go from here. Now, there are a couple of norms that I would set. I'm just going to teach this like I would if I was in class. The first thing is that because we are talking about a very sensitive situation, there may be some thoughts or some images or some topics that come across your mind that may be triggering or may be traumatic. If that is so, by all means, take care of yourself. Engage in self-care, because the discussion of this is going to piss you off. All right? It's pissing me off, but I'm trying to navigate in a way where my passivity, if that is a word, does not impede with the goal of what I'm trying to accomplish. The other norms is that there's no dumb question. I am many things, but I am not a mind reader, so I am going to provide an opportunity for you all to type in information, or rather questions, and I will answer them the best way that I can. Although I am licensed in the state of Illinois, I am not in the state of Minnesota. However, that does not stop me from doing research and making the necessary parallels for us to understand what is going on. I am speaking as me. I do not represent any institution, any organization. This is Natasha L. Robinson. Okay, so the views that are expressed herein may not necessarily reflect the views of organizations that I work with or I work for. All right, this is me, which also means there may be some situations where I'm going to cuss. Okay, this is grown folks' time now. All right, so if there are children, I will try to give you some kind of spoiler alerts to let you know, okay, there's about to be something that jumps out. You might want to put them down. But part of my outrage involves the holy language of cussing. I've never profaned cuss like a, yes. So what you hear is from me and me alone. All right. Chew the meat and spit the bones. So everything that we talk about here that may not apply to you, it may not feel good going down, it may not feel good hearing it. That's fine. Just take what you want, chew it for substance, and then whatever you don't, spit it right on out. Okay? Because we grown. This is a sacred space of accurate and accessible knowledge, but I'm not commenting on anything other than the case involving the murder death of George Floyd. Now, I may make some parallels or some comparisons, but that is my main focus. So if you all are coming on for all of the trolls, I bind you now in the name of the Most High, because this ain't that. And I don't want to have to get you right together on this live. All right? So don't come to me talking about what about the looters and what about the... No, that we're not talking about that. Okay? So calm down and go on the other side of the internet with that. This is a communal effort. So what that means is, although I am the facilitator, as I said earlier, I'm not the manipulator. So there are all of you all who bring a certain level of expertise on here. By all means, share it in the comments. And we're going to go ahead. You can certainly share it. Thank you very much. You can share it on your pages. Please do. Because this is information that we all need to be mindful about. Okay? All right. So we're going to start with the class. Let me get myself together so I can roll up to my notes. And I also want to let you know that some of my comments come from research. So I have one book that this is my textbook that I use. It's called Criminal Law. This is not necessarily an endorsement. I'm just telling you the book that I'm using. Okay. Then I'm using another book, which is a standard in criminal practice, which is by Spitz and Fitzer. If you have ever done a murder case or a murder trial, you are very familiar with this book. It is called The Medical Legal Investigation of Death, Guidelines for the Application of Pathology to Crime Investigation. I have the 3rd edition. Right now, the current edition is the 4th edition, and the 5th edition was published on March of this year. So I'm going to be making sure that I try and get my coins together to upgrade. All right. So here we go. Today, Hennepin County Attorney Mike Freeman announced that there were criminal charges that were to be brought against Derek Chauvin, who was, I don't know if he still is, a Minneapolis police officer. And the Hennepin County Attorney had a very, very brief news conference with the press. And he stated what he charged, or rather what the office charged Derek Chauvin with. Now, I don't have the type of technology right now to be able to share with you videos, but trust me, it's coming. It's just not coming tonight because I literally only had a handful of hours to get my stuff together. So this was not planned. This was something that was urged on by those who were asking me questions. And so I said, you know what? I'm just going to come on live and we're going to have a good old conversation. So feel free to share on your pages. So when the attorney, Freeman, the prosecutor, went on to talk about the charges, what he said is that Derek Chauvin, who is one of 4 police officers, so we won't talk necessarily directly about the officers because they haven't received charges yet. So we're only going to focus right now on Derek Chauvin. Derek Chauvin is a police officer who, if you don't know by now, he is going to be prosecuted for the death of George Floyd. Now, I say death and not murder for a reason. I personally believe it's murder, but the reason why I say death and not murder is because in law, in criminal law, murder is a legal conclusion. Okay, so there are a lot of times that the evidence has to bear out that there is actually a murder, a homicide. That is legal language. Okay, The other thing is that what you may think is a slam dunk case on the street may not be a slam dunk case in court. Okay, and we'll talk about that a little bit later. But what I want you to know is I'm very intentional about why I use the word death instead of murder, because murder is a legal conclusion and death is more of a natural street language, if you will, at this time. Okay, so attorney Mike Freeman said that Derek Chauvin was charged with 2 counts, meaning 2 charges. The first is murder and the second is manslaughter. Now, if you were to watch the press conference, you heard him say murder and manslaughter. What you did not hear initially was the degree of murder and the degree of manslaughter, which is why we are here. And it was not until a news reporter fielded his questions that's when he said what type of murder. So that's what we're here to talk about. Derek Chauvin was charged with 3rd-degree murder and manslaughter. And I'm going to tell you the types that it was. Okay? So, in the state of Minnesota, you have 3 types of murder. You have 1st-degree murder, which is about premeditation and intent. Premeditation and intent. That can carry a sentence of up to life in prison. You have, secondly, in the state of Minnesota, what is called 2nd-degree murder, which is different because there is no premeditation, but there is intent. So you did not think about this or plan this either within a split second or you thought about it and made a plan. Okay? For 2nd-degree murder, there is no premeditation, but there is intent. And the sentencing can go up to 40 years. Lastly, which is what he is actually charged with, is the Minnesota statute 3rd-degree murder, where there is no intent that needs to occur. There is no mention of premeditation, but you do not need any intent. You do not need to be purposeful or intentional or on purpose. This is the statute that he was charged with, which the possible sentencing goes up to 25 years. Now, it is presumed and understood that murder is a felony, which means that if a person is found guilty or pleads guilty, they can receive anywhere up to life in prison. And in some states, they could be put to death. All right? So, with the Minnesota statutes, you have 609.195A. That is what he was charged with, which is 3rd-degree murder. Now, the reason why I'm guessing that he said murder as opposed to 3rd-degree murder is because when you hear someone is charged with murder, you automatically feel like, oh my God, this is such a very serious offense. And it is a serious offense if you start high. They did not start with the most severe, or rather, they did not charge the most severe charge. And I'm going to explain why. So when I was doing my research and I was looking at CNN, they report that the evidence in the case is the following: a cell phone video of the incident, body cameras, witness statements, preliminary report from medical examiner. All right, the cell phone video of incident, body cameras, witness statements, preliminary report from medical examiner. Now, I hear you in my sanctified imagination asking me, well, what's the difference between murder and manslaughter? I'm glad you asked. Here's the difference. A very generic, very general difference. Murder is usually the taking of one's life with malice aforethought. Usually when we think of murder, we think of someone planning it, someone being intentional, someone engaged in premeditation. Premeditation does not always have to happen, but usually murder is something that is intentional, meaning either, depending on what jurisdiction you're in, you intended to do something or you knew or should have known that if you did A, then B was going to result. That's murder. Manslaughter is still involving someone's death, but usually there is no intentionality. There is no purposeful thinking. The Death may not have been intentional, but maybe the actions leading up to the death were intentional. Okay, that's as general as I can state about murder and manslaughter. And for those who are practitioners, those who are law enforcement, if you want to put in the comments what you believe murder and manslaughter is, that's fine, because we're just engaging in a think tank. All right, I'm just sharing my thoughts, because unless you take me for criminal law, I only have so much time. Okay, so again, just to reiterate, Derek Chauvin was charged with third-degree murder, which means you don't have to have intent, and there is no mention in the statute of premeditation. All right, that's the first charge. The second charge that he had was manslaughter. In the state of Minnesota, you have two types of manslaughter. You have first-degree manslaughter, which is up to 15 years in prison. That involves where there's an intentionality, maybe not necessarily the cause of death, but your actions were intentional and those actions led to someone's death. You also have the Minnesota statute second-degree manslaughter, which is up to 10 years in prison, which is, it speaks or blends to a negligence, which means you had a duty or you had a legal responsibility to interact with someone, and during the course of that, someone died. And you were negligent because you breached or you broke that duty, and the causation of your actions led ultimately to someone's death. Okay, so this is what Officer Chauvin was charged with. So what are our takeaways? None of these charges that he has involves first degree, which is the most serious. Okay, he got or was charged with the lesser versions, okay, which is third degree murder and second degree manslaughter. Okay, now the last thing I'm going to say just about this before I go to make sure, because I have slid the comments over because I couldn't see, is that when we are talking about state to state, there is really technically no unified codified criminal code. Every state has their own thing going on. And so what happens when we are teaching criminal law, we look at what's called the model penal code. Model, M-O-D-E-L, penal, P-E-N-A-L code. And that model penal code is kind of like, if you will, a comprehensive list of crimes and penalties and things that states need to watch for, because again, understand, the judges do not make the statutes. Your elected officials make the statutes, which is why it is so important not to just wait for federal elections. Federal involvement does not happen as frequently as state and local and county and village legislation happens. So that's just a free plug. So when we talk about model penal code, the model penal code has 4 types of mindsets that most crimes fall into the category. And I'm going to start from most serious to less serious. So the first is purposeful, which means that you intend to bring about a certain result. In Illinois, purposeful is along the same lines as intentional, intentionality. All right? That's the highest. Then the second one is knowingly, meaning you are practically certain that the result will occur. The third level is recklessly, which means that you consciously disregard a substantial or unjustifiable risk. And then negligently, which is the lowest, which is you should be aware of a substantial or unjustifiable risk, but you're not. Okay? So, model penal code, a uniform suggestion, if you will, of the law, where it's suggesting to different states and different legislatures that there are 4 types of mental mindsets. And these mindsets are important for deciding whether or not there's criminal conduct or illegality. All right? Purposeful, knowingly, recklessly, negligently. And some of these terms change depending upon the state and the jurisdiction. All right? So now I'm just going to flip over to the comments real quick, hopefully, to make sure that I don't miss anyone. Let me take my glasses off so I can see. I used to laugh when my family would say that, and now I know what they're talking about. Okay, so let's see. If you had any questions or comments, put them in right now. I don't see any right now. I don't see any. I just want to make sure we're all on the same page, that we all understand what's going on. What I do need to know is, if you can, make sure that you hit the hearts so that I know that you're still on, or put in the comments that you're still on, because I need the feedback. I need to know that I'm making sense, that we're still connected, and that you can hear me. Okay, so hit the thumbs up or the likes or the hearts or whatever it is that you need to do. Let me know that you're still here. I'm gonna drink some lemonade while y'all doing that. Everybody, okay, I see some hearts. You still here? Okay. So now we have talked about, thank you all so much. This is great. Now we have talked about what he is charged with. Let's we're still in the same vein, but I want to talk about, what does it mean when someone says that they are charged with murder? Okay, this is where I get the big book on this. Whenever and I'm speaking from Illinois now, whenever there is a murder and I or my colleagues had to represent someone charged with murder, one of the first things that we looked at, besides the charging document, which says what the person was charged with, we also looked at the coroner's report. And depending upon how much of a media case it was, or whether it was, a standard murder case, the coroner, we call him in Illinois, the medical examiner, the address is 2121 West Harrison. I can still remember that because that's where I used to go to question all of the medical examiners when I had murder cases. They would write a autopsy report. And within this autopsy report, they would have like a body outline. And the body outline would be a frontal one, and then it would be one in the back. So if, for example, someone died by way of a gunshot, then you would see, according to the drawing, where the gun would be the entry point, and then it would be the exit point if the bullet had left the body. If it hadn't, then the medical examiner would draw on this diagram where the bullet actually was. Okay? They would also give you, little different films or different little x-ray slides. Think of like when you're going to the dentist and they have these slides and they put the cotton in your mouth and they tell you turn this way and then turn the other way. So they would have these slides and pictures of the actual person who was killed. And then they would have a written narrative. And the written narrative would talk about, and I'm going from memory, it would talk about the internal causes of death or internal evidence and the external. So what they would do is they would talk about, okay, this is what we see on the outside, okay, and this is what we see on the inside. And then they would go into very explicit, detailed language to be able to say, based on their findings, there will be a manner of death and a cause of death, okay? I want you to hold on to that. A manner of death and a cause of death. So what are those? Manner of death is where, I guess it's better to explain by way of looking at it here. The manner of death, I'm reading now Spitz and Fisher's medical legal investigation of death, okay? The manner of death is a 4-part classification scheme minus the references to a supreme being, persists as the classifications used for vital statistics registration in contemporary times. So the manner of death is used for vital statistics registration. There are 4. Here we go. Natural, which is death caused exclusively by disease. Then we have accidental death, which is death caused by violent means not due to an intentional or criminal act by another person. You have suicide, which is violent death caused by the act of the decedent, that's the person who is killed or dead, with the intent to kill themselves. And then you have homicide. Homicide is violent death at the hand of another person. That's what homicide means as it relates to a medical examiner or a coroner's report. And then lastly, you have undetermined, which is where a reasonable classification cannot be made. So these classifications are for the purposes of vital statistics. Okay, I want you to hear what Spitz and Fisher has to say. Quote, when medical examiners or coroners indicate a manner of death on a death certificate, they are not making a ruling despite what the press may report. They are merely rendering an opinion to the vital statistics bureaus of their jurisdictions as to how the death should be statistically coded by that bureau. In other words, the determination of manner of death by a medical examiner is an administrative function. All right? That is important because when we hear the word homicide, be like, oh, okay, well, if it's a homicide, then, why can't they be charged with this type of murder? The definition of manner of death is only for the purposes of vital statistics, how they are to code the death of this person. Was it natural? Was it accidental? Was it suicidal? Was it undetermined? Or whether it was homicide? Okay? So the manner of death is, in this case, homicide. That is not a legal conclusion. That is simply something that talks about the vital statistics and how that person's death is coded. So now we're going to talk about the cause of death. Remember, I told you in these autopsies, they have a couple of findings: the manner of death and the cause of death. All right, so the cause of death, I'm still with Spitz and Fisher. The term cause of death means different things to different people. For the purposes of forensic medicine, vital statistics, and the law, the cause of death is the original underlying medical condition which initiates the lethal chain of events culminating in death. I'll say it again. The term cause of death means different things to different people. For the purposes of forensic medicine, vital statistics, and the law, the cause of death is the original underlying medical condition which initiates, which starts, the lethal chain of events culminating in death. Now, why is that important? I'm finna tell you. Let me go over here to my trusty dusty websites. Okay? While I'm going over here, if there are any questions or comments that you have, just put them in the comments and I will be able to see them. But I want to read for you, as part of what was in today's criminal charges, there was also information about the autopsy. Now, it's not the last autopsy, but it is a preliminary finding and report. So this is what is in the criminal complaint. Quote, the autopsy revealed no physical findings that support a diagnosis of traumatic asphyxia or strangulation. Mr. Floyd had underlying health conditions, including coronary artery disease and hypertensive heart disease. The combined effects of Mr. Floyd being restrained by the police, his underlying health conditions, and any potential intoxicants in his system likely contributed to his death. The combined effects of Mr. Floyd being restrained by the police, his underlying health conditions, and any potential intoxicants in his system likely contributed to his death. Now, let me tell you why this is a problem. This is a problem, or this is at least a challenge, because what we are doing is we are victim blaming, is what we're doing. Because remember I started the video earlier talking about lingua franca, talking about how there is a way in which there is a legal speak or a legalese where if you are not tapped into or tapped to someone who is able to explain what, as my pastor says, what the text says and what the text does not say, then it may kind of run past you like, oh, okay, well, these are his findings. Let me tell you what this means. Or let me tell you what I think it means. The first thing is that it's telling the audience that Mr. Floyd did not take care of himself because he had a coronary artery disease and hypertensive heart disease. Okay? And we know the statistics that talk about African Americans, especially black men, and about how heart disease is the #1 killer. The second reason why this is important is because it is trying to break the causal chain. Because if he has heart disease, and that is a factor into why he dies, then that mitigates the responsibility or the legal accountability of the officer. So if he was a perfect person in perfect health, then you would have a different or a less complicated way of connecting what his health was with how he was treated, with how he died. But when you have the coroner medical examiner saying in a preliminary report that Mr. Floyd has heart disease, now you are breaking the chain. You're breaking the chain of causation, which is probably one of the things that the prosecutors considered when deciding what to charge him with. Okay? The other thing is that when they talk about potential intoxicants, what they are trying to say, or what they are actually saying, is that, well, we don't know if he was high or not, but we just gonna throw that out there. We don't know if he had a drug addiction, because you know, all black men, they must be on drugs or buying drugs or selling drugs. They must be high. They must be drunk. They couldn't possibly just be. Okay? It always has to be some other type of effects. Okay? Potential intoxicants. That is code for if this man is high. Okay? If he's high. If he's drunk. Because if he's high, if he's drunk, then that gives the officers the legal reasons to decide why they did what they did. Okay? So pay attention. Here's the last thing as it relates to that. When you are publishing these type of reports, you are not just publishing to the public. You are publishing to potential jurors. So if this former officer decides that he wants a jury trial, you now have the information being given to potential jurors who are watching and reading, and they're deciding before they have to decide. So when we talk about the court of public opinion, this information, even though it is coming from the prosecutor's side, it is suggesting, without there even being an official legal hearing, that the coroner already thinks that the health conditions is a justification for why he died, or at least it lended into the reason for why he died. And if you can break that chain between what the officer did and what the decedent went through, if you can break that, then you have a greater chance of the police officer being acquitted or found guilty of a lesser offense. Okay, do we understand that? It's as my students say, it's levels to this shit. Okay? This is not just accidental. Okay? It is a very intentional, it is a very systematic way of bringing in information without the legal ramifications of rules of evidence, of trial and trial protocol. Okay? It's just throwing stuff on the wall to see what sticks. Okay? So, also understand, because I'm reading the comments, Also understand that you have a prosecuting officer or office who is prosecuting one of their own. Because when you have cases that are being prepped for trial, it is usually the police and the prosecution who are working in tandem to make sure that justice is served by prosecuting, trying, and convicting the person who has violated criminal laws. So, when you have a prosecutor who is trying a police officer who historically has been working together, then usually, most cases, there is a coroner or a medical examiner who also works alongside the prosecution, even though traditionally they are supposed to be independent. Now, I am not saying that every coroner is in bed with figurative bed with prosecution. That's not what I'm saying. What I am saying is that even though the medical examiner is independent in their findings and they are making medical findings, those medical findings have legal inferences and they have legal outcomes. And unless you as a defense attorney speaks one-on-one with the coroner or with the medical examiner, you will just take that report and you will just say, okay, well, it couldn't possibly be another way. Or you will do what some parties will do, what they call a stipulation, which is where they say, you know what, we don't want to bring in the medical examiner or the coroner because they may be working a lot of cases, and with the pandemic and with everything, they're overwhelmed, which they are. And so we ask that we stipulate or agree to the document, which is saying no one has any arguments about what is in the body of this document. But if you don't read that document, then you may be agreeing to something that will tank your case and hurt your client forever. Okay? So, please let it be known, I am not saying that every medical examiner and coroner automatically writes autopsies to help the prosecution. That's not what I'm saying. But what I am saying is that unless you do your due diligence, you will think that there is no reason for you to question the autopsy. So now in Mr. Floyd's case, we have a situation where the prosecution has to try and keep this chain tight. They have to be able to say that no matter what Mr. Floyd had, the defendant, the police officer, had no reason to do what he did, and it was the police officer's actions that caused Mr. Floyd's death. If there is not that connection, then the defense, who represents the officer, they will prevail. Okay? Now, I'm going to pause, and I'm going to go back, and I'm going to see if there are any questions or comments so that I can address them. Because I ain't trying to keep y'all up here all see, I'm already past my time. Okay? But I'm going to take my time on some of this stuff, because this is why I'm here, and this is why y'all here. Okay, let me go back. I promise you, when I get my Zoom stuff, it's going to be better. Okay, potential intoxicants equal to absolutely. So the more and they very slick with it. Potential intoxicants. If it's potential, why the hell are we talking about it? If it's a preliminary discussion, why are we even talking about it? Okay, it's just putting enough information in there to have the potential jurors and the judge be like, potential intoxicants. Okay, either meaning they know that there are some intoxicants in the body, but even if they don't, you can't unring a bell. Once you say potential intoxicants, once you talk about his health status, now the wheels are turning for potential jurors and the judge. Okay? Even if he was high, there's a good chance he would still be alive before the foot on his neck. Yes, in everyday conversation, I would agree with you. Okay? But think about it this way. It depends upon what he is allegedly high with. If he is allegedly high with cocaine, because remember, systematically, he couldn't possibly just be, a regular brother. He has to be a brother with a drug addiction. If he is high with cocaine, one of the side effects of cocaine use is aggression. So if he is being aggressive, then that then gives the police officers reason to be able to use excessive force, use of force, deadly force. Do you see where I'm going with this? Okay. Okay. Who pays the coroner? Great question. I think it is the county. Okay. So for Cook County, I would presume that the county pays the medical examiner, which would then mean our tax dollars. Okay. Is there a way to connect his restraint in a way to say promote or activated his health? Is there a way to connect his restraint in a way to say it prompted or activated? Yes, I'm getting to that, Ship. So hold on to that. Hold on to that. Yes, a health condition is contributory factor to death. It is exactly that. In civil law, they call it, well, sometimes in criminal law they call it, but in civil law they call it proximate cause, which is what the officer did, the proximate cause to a person's death. And if there are any intervening factors or reasons, then the more factors that are present, you really want the police officer's actions and Mr. Floyd's death to be like this. But the more there are things that intervene, the more separate they become, the harder it is to get a conviction. Okay? Is it okay for police action to be the catalyst or accelerant? Tell me what you mean by that question, Sora. Is it okay for police action to be the catalyst or accelerant? Okay. Let's see. How does the system ensure an unbiased That's a whole nother live. How does the system ensure an unbiased process? I'll come back to that. So the defense should bring up the credibility and characters of the officers. No, the prosecution should, cousin, because remember, in this case, the prosecution is Hennepin County. The defense is the police officer. So the police officer would be saying why I felt justified in doing what I did, why my force was reasonable. If using the language of Graham versus Connor, I think that's the case, the United States Supreme Court case that says that the determination for a police officer's use of force is reasonableness, which means a whole bunch of words about looking at the specificity of the case and what led to the officer having to use force. If the officer's act accelerates the decedent's underlying, I can tell you went to law school and graduated. If the officer's act accelerates the decedent's underlying health conditions, that lessens the defendant's charges. If the officer speeds up the health conditions, does that lessen? It depends. It depends. It depends. Could the family or defense get another coroner? They could, but I assure you it's very expensive. And not only can you get another coroner or another medical examiner, you have to get one who is licensed in that state, who is accredited, and who is going to be recognized by the prosecutor. I'm sorry. It depends. You can have Mr. Floyd's family hire a coroner, or you could have the police officers say, get another coroner. But he is not going to hire another coroner. You want to know why? Because the way that this is written up, it helps him. So the family could try and say, can we get another coroner? Okay, but it just really depends. Let's see. Yes, the prosecution will bring up the officer's credibility. It depends, though. It depends. And we're going to get to the depends. Let's see. You may get this later. How did the judge decide whether the defendant will serve? Yes, I'll get to that later. What happens to the autopsy is different results. What will happen is you have this county medical examiner who is going to be saying, okay, I'm an expert, blah, 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 blah. And he, or rather the office, will be the office that is usually relied upon. If they get another medical examiner or coroner, not only would they have to pay for that out of pocket, but there would have to be probably a hearing to decide whose report are you going to believe. Now I feel like I'm in the Bible. Whose report are you going to believe? Are you going to believe Hennepin County? Are you going to believe the hired coroner? Or are both of them going to be considered? I have never been in a situation like that, so I don't know. Is a short answer. What happens if the toxicology report comes back clean? If it comes back clean, it just comes back clean. The defense would not be able to say that there was any type of drug use or aggression. Well, rather, let me say it this way. The prosecution can say there was no aggression on behalf of Mr. Floyd, and therefore Mr. Floyd would not be as victim shamed as he is right now. Oh, but if that toxicology report comes back with just a trace, he could just have a little white smudge in his system. If he has it, you're going to hear about it. Okay? Let's see. The old New York. So they got another examiner, the old New York examiner. The family hired him. Okay. So this is going to be interesting to see. Thank you, Charity. This is going to be interesting to see how this is going to occur. Is the judge going to allow both autopsy reports to be considered and published? And if so, how is that going to work? Okay, because the defense is not asking for another coroner. So this is going to see how this is going to be interesting how it played out. So if the police had not applied force, there would be no death. But because the force existed, it's okay for force to lead to death. That's what the defense is going to be saying. Look, Mr. Floyd resisted. Well, let me back up. The defense is probably going to argue we showed up to the scene because there was a call that he was using a fake $20 bill. We approached the suspect. When we arrived on the scene, we pulled our guns out. We told him to get out of the car. When he got out of the car, it ultimately led to him resisting arrest. And so once he resisted arrest, we handcuffed him for our officer safety to make sure that he was not carrying any type of weapons or there was no danger that was occurring. And once they handcuffed him, then he falls to the ground. This is all in the criminal complaint. He falls to the ground, and then once he falls to the ground, the officers, they pick him up, they walk him across the street, they try to get him into the squad car. One way, he refuses. So then the defendant goes to the other side of the car to kind of help pull him in. He refuses. They put him on the ground, and then that is when the officer puts his knee on Mr. Floyd's neck. Okay, this is all in the criminal complaint. If you are my friend on Facebook, I have published the link for showing the criminal complaint. But if you have not found it, it's on CNN. CNN has a link that talks about the criminal complaint. Okay, saying right now the coroner is collaborating with the. We sure gonna find out. We are sure going to find out if there's any collaboration, which then, of course, there will be a motion to exclude or strike the autopsy report because it is biased. Okay, so a lot of this is up in the air because it's still early. These charges just happened this afternoon, so we're going to see what they're going to say. Okay, so let me just move on. We talked about manner of death, and we talked about the cause of death. This is what I want to talk about also. In the criminal complaint, I'm not even going to paraphrase it. I am going to read it as I see it. Okay, so let me pull this up because this is public knowledge, what I am reading. Let's see. Okay. So I'm going to start reading. The defendant, whenever I say the defendant, I'm talking about the police officer. I just say police officer so we won't be confused. The police officer pulled Mr. Floyd out of the passenger side of the squad car at 8:38 p.m. and Mr. Floyd went to the ground face down and still handcuffed. Another officer held Mr. Floyd's back and another officer, Officer 3, held his legs. The defendant placed his left knee, the officer, Chauvin, placed his left knee in the area of Mr. Floyd's head and neck. Mr. Floyd said, quote, "I can't breathe," end quote, multiple times and repeatedly said, "Mama," and "please" as well. The defendant, the officer, and the other two officers stayed in their positions. This is what I want you to pay attention to. The officer said, quote, "You are talking fine," end quote, to Mr. Floyd as he continued to move back and forth. Another officer, Lane, asked, quote, "Should we roll him on his side?" And Derek Chauvin says, "No, staying put where we got him." Officer Lane says, quote, this is what I want you to pay attention to, "I am worried about excited delirium or whatever." The defendant, Derek Chauvin, says, "That's why we have him on his stomach." I'll say it again. Officer Lane, another officer who was on the scene, says, "I am worried about excited delirium or whatever." The defendant, Derek Chauvin, says, "That's why we have him on his stomach." Let me tell you why that is important. The reason why that is important is because remember we talked about legal words and legal terms? Excited delirium is a medical term. It is also known as agitated delirium, which means that these officers are now speaking code about whether or not the person that they have in custody has mental illness. Did you hear what I said? Excited delirium is also known as agitated delirium. It is something that is listed in the DSM-5. That is the big medical Bible that talks about different types of mental conditions and mental illnesses. Okay? So when they were talking, when these police officers were talking, they're having this conversation about whether or not the posture that they are using is something that could heighten or expand or intensify mental illness. Okay? And as attorney Kanisha Atkins says, yes, excited delirium can allow for forceful restraint, which means if you have a mental illness and you are engaging in excited delirium, the police can forcefully restrain you. Okay? When I did the research, because I am not a medical doctor or mental health specialist, the DSM-5 talks about delirium diagnoses. And it says in the background, now when I'm talking about in the abstract, I'm looking at BMC Medicine of biomedicalcentral.com. And it says in its articles that delirium, I'm quoting off, delirium is a common and serious problem among acutely unwell persons. Although linked to higher rates of mortality, institutionalization, and dementia, it remains undiagnosed. Okay? An altered consciousness has been regarded as a core feature of delirium. The fact that consciousness itself should be physiologically disrupted due to acute illness attests to its clinical urgency. Okay? Another website that talks about delirium and excited, what's the term that I use? Excited delirium. Okay? On this website, Medscape, it says, a careful and complete physical examination, including a mental status examination, is necessary. Testing vital signs such as temperature, pulse, blood pressure, and respiration is mandatory. Patients have difficulty sustaining attention, problems in orientation and short-term memory, poor insight, and impaired judgment. Key elements here are fluctuating levels of consciousness. So what that means is when you have the police officers using this term excited delirium, what that means is either they have been trained on how to work with suspects who live with mental illness, or they knew or had personal knowledge about it. I think it is more that they had the training. Okay, but why this is important is because of the fact that they did not care. They didn't care. And that is what is infuriating, is that they didn't care. So what you have, as I tell my students all the time in criminal law, and this is no shade, no attack on my law enforcement brothers and sisters. But what I say is that the weapon that can be used by the police for police officers when they do not make the decisions necessary to still protect the person that they are arresting is not the taser. It is not the gun. It is not the billy club. What gets weaponized the most in arrests, especially illegal arrests, is discretion. That is the weapon that law enforcement has, which understandably, you don't want someone always telling a police officer on the street, hey, you need to call back to base, or you need to call back the department to make sure that what you're doing is really what you're supposed to be doing. No, you want police officers to be empowered with the ability to decide right then and there what they're going to do. Okay, so it is a good thing, but it becomes weaponized when police officers know protocol, they know policies, and they decide intentionally not to follow it. That's a problem. Okay, and if it sounds like I'm getting angry, it's because I am. Okay, so by their own words, they understand that there is a possible mental illness. And if it is, we're only going to follow protocol for so long, which is why Derek Chauvin says that's why we have him on his stomach. That lets me know that these two men know about the protocol for dealing with someone who may have mental illness. And to add insult to injury, if Mr. Floyd lives with mental illness, I don't know if he does or if he doesn't, but if he does live or did live with mental illness, then what they saw out of his actions was not resistance, it was his mental illness. Do you get what I'm saying? Let me calm down. All right, so you already know the timetable as it relates to from the time that Chauvin puts the knee on his neck until the time he removes it is damn near 8 minutes. 8 minutes. If I were to sit on this live for 8 minutes, I promise you, you would be uncomfortable at 1. Because you'd be like, oh, so we just gonna sit here? We not gonna talk, we not gonna engage in anything? Now take that 1 minute and add 7 minutes to it. Actually, round up to 9 minutes. That's how long Mr. Floyd had Derek Chauvin's knee on his neck. While he is saying, I can't breathe. While he is calling for his mama. While you have bystanders recording this and telling the officers and yelling to the officers, please, he's dying. And they did not move. Okay? So I'm trying to see if I have covered everything that I need to cover at this time. This is still an ongoing conversation. One of the questions that a lot of people ask me is, well, we have video, we have pictures, we have footage. Why is this even an issue? And my response is that there is a difference between street evidence and legal evidence. Just because something has been filmed or because something has been taken pictures of, that does not mean it rises to the level or it passes the rules of evidence. When we talk about the rules of evidence, they are created so that the evidence that is used in cases have the weight and the admissibility necessary for people to rely upon these pieces of evidence. Because think about it, by the time it goes to a judge or a jury, this may be months, in advance, way on down the line. But those people, those decision makers, they were not on the scene. And so you want to make sure that the evidence that is presented is evidence that hasn't been tampered with, evidence that has not been purported to be something other than it is. And so when they're talking about they have cell phone video, body cameras, things like that, do not believe for one instant that that automatically leads to a conviction. Because there are evidentiary objections called foundation, hearsay, summative, speculative. Speculative is you just got the witness up there guessing. That's not evidence. That's forecasting. Hearsay is using something out of court to say, well, based on the fact that it was said or done outside of court, it must be what it really must be. Okay? But foundation is saying just because you present evidence of a video or a body cam, that doesn't necessarily mean that you have proved who took this video, where was it taken, how was it kept, was there anything impeding the view, was there any edits that was done to the video. Okay, so just because there's a whole bunch of videos and pictures going around, do not think that that is a slam dunk by any stretch of the imagination. Okay, because you still have to pass the rules of evidence. Okay, just give me a minute. All right, so I'm gonna look at I'm gonna close this up because I don't want to get away from your questions. And maybe some of your questions will address what else I have on here. I need better light. Let's see. Let me see if I can get some better light. I'm going to take you with me, which is why I'm glad I'm on my phone. All right, so excuse me. Talk amongst yourselves. You know what? No. I don't want to go over here. I know where I can go. Y'all still with me? I know some of y'all is past your bedtime. I know it certainly is mine, but I could not rest until I had this conversation. All righty. Y'all still with me? Hopefully this is better light. So I have moved into my family room. Is this better? I hope so, because I don't have no more light. Okay, so let me go back. Let's see. When he called for his mama, can they use it as hallucination? They could, but you would have to have a medical expert to testify to that. You would have someone who would now let's presume, let's say that Mr. Floyd had a mental illness. I don't know if he did, but if he did, then the question would become, was he being treated by anybody? And if he was being treated by anybody, then can they get the subpoenas necessary to get the psychiatrist or the psychologist or the therapist to testify to what he was being treated for? Okay, because you want to make sure you don't violate any hippie, Lord Jesus, I know I'm tired, HIPAA laws. Okay. Secondly, if the prosecution were to hire someone to talk about his reactions to him being arrested, you would have to get an independent expert, which means more money, which also means that just because an expert is testifying does not necessarily mean that the testimony has to be accepted. That testimony can be refuted and say, well, this person is not qualified to be able to testify to the mental state of Mr. Floyd because he's never met Mr. Floyd, she's never met Mr. Floyd, what have you. Okay. The other thing is we're still on victim blaming. And if we're not careful, I'm not saying that this happened in your question. I'm saying if we are not careful in general, then Mr. George Floyd is going to end up on trial, not Derek Chauvin. Okay. Mr. Floyd is already being prosecuted because understand, they are talking about the fact that the reason why they even came to the scene is because he was under suspicion of forgery, i.e. passing a $20 bill, which is a nonviolent offense, which is why I don't understand guns being drawn when they approach his car. But another conversation for another time. The fact that they said underlying health conditions contributed to his death, not the actual strangulation. Yeah, it is crazy. At no point in the 8 minutes did anyone think to check. No, I have read reports about the fact that there were some EMTs that were on the scene that kept asking, could they check him? And they were denied. Then when they did check him, he was already dead. He was already dead at the scene of the crime, and he was just pronounced dead when he arrived at the hospital. Let's see. Let's see. Yeah, the rules of evidence, Judge, you know. You got state rules of evidence. You got federal rules of evidence. You just be like, you know what? Fuck it. That's how I feel about it. But how many black men sitting in prison use that? Yes. There are a whole bunch of people, clients included, that have been in prison for nothing other than he said, she said, or he said, he said, or she said, she said, or they said, which is why you have projects such as like the Innocence Project and the Equal Justice Initiative with Brian Stevenson. This is why all of these things are so important. This is why you have stories like John Burge, who was literally beating confessions and statements out of people in Chicago. Why people like him, there's a special place for them. And I hope they find it. I just put it like that. Let's see. Could the hallucinations be caused by asphyxiation? Good question. Answer, I don't know. I don't know. Because, and the reason why I don't know, so I don't want it to seem like I'm flippant. The reason why I don't know, nephew, is because of the fact I'm not a medical doctor. And so the other thing is, this is just the preliminary autopsy. I'm sure that there are still going to be some toxicology reports that are going to be done. A more comprehensive report is going to come out, and we'll find out then whether they can be. But I do not feel comfortable saying that they can be, because that's not my area of expertise. All right. How do we get from forgery to excessive force? I mean, discretion. Weaponized discretion, I should say. Because I want to be clear. Not every police officer, as you know, as you experience, is out here doing this. But I'm sick and tired. Let me tell you, this is me, Natasha, talking. I'm sick and tired of the weaponization of discretion. If I were to write a book or a paper, that's what I would talk about. The weaponization of discretion, which is, you have the United States Supreme Court basically saying, look, it's the issue of whether it's reasonable or not. Okay, that would be like me saying, well, what color is it? Well, it depends. It could be green, lime green. It could be green. It could be, I mean, it just really depends. And I understand why that provision is there, but it is the way in which it is used that makes it frustrating. I don't know how anyone would be able to make the determination that this was not excessive in nature. Let me tell you something, and I can't remember the person who did this quote. But once I find it, I'm going to share it with you. This person, help me, Holy Ghost. This person was the chief of the International Association of Police Chiefs. And he said, and I am paraphrasing, that the use of force is on a spectrum. And once the suspect complies with whatever level that you use, once that compliance has been sustained, anything done by the officer after that is automatically excessive force. So, for example, if you handcuff me and I don't resist you, and then you take a taser and put it in my side, according to this definition, because I have already obeyed and complied with your request, you are automatically engaging in excessive force. Because what force is needed? I've already followed your instructions. Okay? Let's see. Prosecution excavating the intent of the officer. You know, it depends. It depends on whether there is direct evidence that talks about his intent or whether there is circumstantial evidence. Because remember, intent is not something that you can look at a situation. You usually have to look with the statements of the officer or statements made on the scene. And so we don't know if this officer has made any statements as to what he felt he should have done at the time. If I were his attorney, I would tell him, shut the hell up. I'd tell him, don't say nothing. Okay? That is what I would tell him. So we're going to see. Can excited delirium be used as a reason for excessive force? Think there were those terms to cover themselves. Yes, according to my sister friend, Attorney Atkins, you can use that as force. It's a certain term. Let me get to it. I got like 40 things open up on my computer. But yes, it can be force. Kanisha, if you could put that information that you put about how excited delirium can merit use of force. Okay, remember I told you this is a collaborative effort. Let's see. I see some of my scholars, some of my former students on here. I see you all. What charges would a person face for helping Floyd, for example, push an officer off his neck? Would it be, let's see, Ship, it won't show me the rest of your comment. Would it be a felony charge? Great question. Okay, so for the other 3 officers that were there, what are the charges that they can face? They can face the same thing that Derek Chauvin could face, or they could also face what's called conspiracy to commit. Which is, instead of do the crime for me, which is solicitation, do the crime with me. They could be charged as accessories. Well, it depends on the state. Whenever there is a crime, there are at least 4 roles that can be played. Okay? The first is the principal. The principal not is in the school, but the principal is that is the main actor, the main mastermind of the crime. Then you have the accomplice. The accomplice is the person who, what's going on with my lighting? The accomplice is the person who is like the right-hand person. They're the person who is assisting. No. Okay. Then you have, after that, you have the accessory before the fact and accessory after the fact. The accessory before the fact is the person who is the planner. They says, okay, if you're going to rob this bank, this is the best exit routes. If you are going to, turn off the camera, this is the best time in which you need to do that. That's the accessory before the fact. The accessory after the fact is the person that helps them hide or help them escape. Generally speaking, the accessories are never on the scene of the crime. They're never at the scene of the crime. They usually help before or they help after. It's the accomplice who is usually on the scene. And that's generally speaking because jurisdictions have different terms. If the 3 officers were going to be charged, they could be charged as accomplices. I don't know what they would be facing. or their possible sentences. But yes, they could be charged as well. Let's see. Yes, reasonableness. They said it's a objective, subjective standard. It's whatever people want it to mean. 8 minutes, that will be the dagger. Cousin, it depends. If the defense, which is the attorneys for the police officers, if they were to say, even though he was on his neck for 8 minutes, they did it, one, because he was resisting, and two, the foot on the neck was already a death sentence because the man was already going through some type of shock and because of his health or heart disease. So what I mean is that the defense could argue, well, look, he was already sick anyway, or he was already dying or going through excited delirium anyway. And so we need to figure out where to stop the clock. Do we stop the clock with accountability with when the neck was, when the knee was in the neck, or was he already ready susceptible to death? It's going to be I won't say interesting, because I don't think this should have occurred at all. I don't think it's going to be interesting, but we're going to see how they play this out. Okay. Does Chevron past record of alleged offenses carry any weight? Great question. The answer is it depends. A lot of law, criminal law, talks about it depends. The prosecution is definitely going to say that this is a history or a pattern. The defense is going to say that we wish that this evidence is going to be excluded because of the fact that it is more, and the term is prejudicial than probative, which means it's more prejudicial against the defendant, who is supposed to be presumed innocent, than it is informational. So they're going to try and keep that out. They're going to try and say, okay, so what if he got reported 4 or 5 times? And so what if Joe Biden's possible presidential, vice presidential pick was also the prosecutor who did not follow this up? And so what? That doesn't mean that he did this. Okay, so it depends. Do we know if there were prior complaints? Yes, we do know there were prior complaints of this officer. I can't get to it now, but at least 2 of the officers had about 4 or 5 complaints between the 2 of them. Let's see. Someone just posted on my page that Keith Ellison said, even if Floyd had underlying conditions, it doesn't matter for the crime, as the perpetrator assumes the risk of the condition of the victim. My response to that is, while it shouldn't matter, and I'll just leave it at that. Hey, Uncle Reggie. Okay. So I think I have answered all of the questions or comments, and I came on at 9:30. It is a little after 11. So I don't want to hold you any longer, but I hope, and I will probably have to do another live to kind of explain some things, or to do a deeper dive of some things as information is shared with us. Okay. But I wanted to just come on and at least tell you the difference between murder and manslaughter, why it was 3rd degree. They probably charge him with 3rd degree because they think that based on the autopsy and based on witness statements, which we have yet to hear and see, that there was no intent by the officer to kill the man, Mr. Floyd. I can see them arguing that there was intent to, yes, put his knee on his neck, but there was no intention to kill. And that's what 3rd degree murder speaks to. 2nd degree manslaughter is talking about there being a negligence in which he should have known better. That's basically what that statute is saying. Okay. So yeah, it is past all our bedtimes. Well, it may not be if you are a night owl, but I just wanted to come on, not to belabor the point, but to kind of make some things clear. I will make sure that as this case progresses, I will come back on and you will hear some information about me coming out of my comfort zone and creating some sites or resources where we can have more of these discussions. And I promise the next time that I come on, Lord willing, Creek Don't Rise, I'm going to have it on Zoom so that I'm able to stream to Facebook and to YouTube. Okay, so it's going to be archived. Okay, so this is pretty much what would happen if you were in my criminal law class, except I would probably be standing instead of sitting, and I would be able to hear your questions in real time. Okay, so make sure that you are able to share this with other people. Like I said, I am not a manipulator of information. I am a sharer of information. You will see and hear other people who will have their take on it, but I wanted to share my take and the take of other legal sisters like April Prayer, like Kimberly Malone Lockett, like Denisha Atkins. The reason why I wanted to share that is because it's high time that you hear from the women, Black women. And our voices have been too manipulated, too ignored, too marginalized for way too long. And you might be surprised to find out how many Black women are lawyers and judges and probation officers and police officers and sheriffs. And so it's high time that you hear from the women. And I am glad to be able to lead the charge. So yes, I will make this video public for later viewing and sharing. Thank you all so much. Thank you. I'm just going, kiss Addie for me. Thank you. My Zelle and my Venmo. Let me tell you something. I always wrestle with this because, like I said, I was asleep when all of this shit started happening. And then when I woke up, I got texts and calls and inboxes. And I said, you know what? Let me get online because I'm tired of Facebook pulpits and lecterns where people watch one episode of Law and Order or Criminal Minds, and all of a sudden now they got a law degree. And I said, it's easier for me to come on live than it is to type my response. So having said that, I just wanted to render my service because I feel that the understanding of law should be accessible for everybody, not just those who have the money or the connections. So if I type in my Zelle or my PayPal, it will be because those will be financial investments, if you will, to help expose this platform. Okay, so I'm going to I'll do that later. Okay, because I can't find how to even type on my phone if I needed to. Let's see. I see you on CNN and ABC. See, and we gonna speak into that because I think that we should be on television just other than as a witness, a victim, and a defendant. I'm tired of that shit. I'm tired of it. And when we have people like April Prayer who are coming and speaking life about law and having her platform, Justice Junkies, that's shout out. Make sure you go to her side of the internet and get her board game that she created, as well as the videos that she does live each and every week. When you have persons like that who get on like NBC and you're waiting and you're watching and you're waiting and you're watching, and then they cut her segment out, that's frustrating. We should not only be seen as the criminal or the victim or the witness. We need to be exposed as who we are, which are experts of the law, because we are out here in these streets like everybody else. So I definitely hope and pray that this will help. Let's see. Blah, 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 da, 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 da. I'm just going through making sure. Wrestle more. We asking for information. Okay, hold on. Wait a minute. Damn. Let me see if I can. How do I respond? Let's see. Because I'm on my phone. Okay, I'm going to hold on. Okay, so I'm going to try and do it. Y'all can look at my lovely ceiling fan. Zelle. Hell, I don't know because I don't send myself money. Let's see. We're going to try and see if we can go with this. Zelle is my email. Zelle and PayPal for that matter. I hear Cash App is shady, so I'm not going to give that, but here they are. Okay? I just I just typed it. I just typed it at the bottom. Okay? Her name, Patricia, is April Prayer. APRIL Prayer. PREYAR. Her Facebook page is Just Us Junkies. Okay, it's a play on justice, because sometimes justice ain't just for us. Okay, Justice Junkie. Okay, make sure you go over there on her side of the internet, and I'm telling you, she is a blessing. She comes on almost every week, discussing real live cases and her take and her experience. And what people may not know is she and I started in the public defender's office together. So that's how we know and love each other. Okay. Let's see. I'm just trying to make sure I don't miss any questions or comments. We need a law 101. Yes, I'm working on it, because, I want to make sure that I still abide by the ethical components of being an attorney licensed in Illinois. There are some things that you can and cannot do, and I want to make sure I don't do it. Otherwise, I'm going to have a different type of life. Hey, Juanita Lawson, that was another partner of mine with the Public Defender's Office. Okay, hey, Sue, my Sue, one of the wonderful prosecuting friends that I have. Let's see, I'm contributing to legal literacy. Let me tell you, Kanisha, literacy is everything. Okay, and there are different types of literacy. There's a literacy of reading. There's a literacy of speaking. And I don't want to make sure that those who find themselves in the criminal justice system for whatever reason, that they are empowered, okay, with the truth, no less. Oh, hey, April, are you on here? April, put your information down here. April, put your information down here, because the people are asking, because I was shouting you out. Okay, I don't know how to pin. Pin. You just going to have to scroll. Let's see. I put it down here one more time, because as I told you, this is all new to me. But I promise you, next time I come back on, I'm going to have my stuff together. PayPal and Zelle. It's the same thing, okay? But I'm only putting this on here because some people on here tried to hate me and tell me to provide it. So that's what I am doing. But if you know anything about me, you know that I've been doing this for a long time in terms of sharing information, sharing accurate and accessible information, because I feel, I think it's a Bible verse, my people perish for a lack of knowledge. That is true. But if you don't have accurate knowledge, or if you don't know where to go to get the knowledge, it is very frustrating on top of an already frustrating situation. So I have gone to schools, I have gone to churches, my own church, working with the legal ministry. I have, just tried to make myself accessible so people feel empowered with the right information. Okay? All right, it is 11:15 Central Standard Time. Thank you all so much for being here. I really appreciate it. I will make sure that I will have my session next time where we'll have a bigger audience. I'm gonna give me one of them ring lights so that you can see my beautiful face in the pandemic, and that will be that. All right, if you have any questions, also that same email that I put on, gotjoy1974@gmail.com, send me your questions there, okay, and I'll be happy to answer them. All right, so got joy. G is in goat, O is in other, T is in Tom, J is in Jehoshaphat, O is in other, Y is in yes, 1974@gmail.com. If you have any questions, email me, and I will be happy to write you back. All right, with that, I bid you adieu to you and you and you, in the words of the children Von Trapp from Sound of Music. Yes. Okay. So you all be safe, stay hydrated, and take care of yourself. That is a form of radical self-care to end on Audre Lorde. Take care of yourselves. Bye.